Hey everyone, Harry here to talk about continuing uncertainty and sort of legal limbo of the administration's plan to forgive student loans. And the latest from yesterday is the Supreme Court refusing to lift a broad injunction that the Eighth Circuit entered that keeps the latest plan to forgive student loans from going into effect. All right, so this is part of a fight over years where Republicans have tried to keep the Biden administration from offering loan forgiveness. Student loans are a bigger source of debt in this country than credit card debt, and arguably have a more crippling effect on debtors because we're talking about people who are just, starting out, trying to kind of achieve the American dream, move up one step on the ladder, and they have crushing loans that cannot be discharged in bankruptcy, and often it results in their having to more or less go off the grid. No chance of robust participation in the modern economy. So the Biden administration has tried several ways to give really substantial loan forgiveness. And the last effort that they did under a particular program, so it was under a special fund created for actually 9/11. Anyway, the administration had used that fund to fund the relief, and the Supreme Court struck it down, saying they didn't have that authority. The administration went back and refashioned the program, which already has provided relief for millions of students, and that relief is not challenged here, but it's going forward. But they put it under a different legal peg. It doesn't matter deeply the sort of legal weeds here, but it's the Higher Education Act, and therefore it has to do with the Congress's ability under the Interstate Commerce Clause to regulate education, same as it does, say, in Title IX. But right away, this is back. It was to go into effect in July. As soon as it was announced, 8 attorneys general, all Republicans from different states, sued. And their basic argument is this is more authority than Congress meant to provide the administration and the education department. And so this is all part of the ongoing battle here in the court about when administrative agencies can be deferred to, when there are so-called major questions doctrine, which the Supreme Court has basically coined in the last few years as a way of making it harder for administrative action in important instances to take effect. Anyway, that is their argument here, and a district court enjoined part of the new SAVE, that's the acronym SAVE plan, and then the Eighth Circuit did it even more broadly, imposed a really very broad injunction at a panel of 3 Republican appointees did a very broad injunction, which means they basically credited the idea that the legal argument and said, they're likely to prevail here. Are the attorneys general now? To me, there's a whole sort of issue of why they are entitled to challenge it. It's really just about the argument is just this is too much money, and it's money that could be better spent. But why there's harm to the states, I think, is an issue in the case that will be have to be litigated down the line. But the big point is, for now, it's frozen and it can't go forward. And in the sort of twilight of the administration where we are, it's likely that it remain there. The Solicitor General came in and said, don't do this, it's going to harm not just harm millions of taxpayers who needed the relief and mess with the economic planning here, but it's going to eventually create chaos, because if this is green lighted down the line, we're going to basically have to recalculate for everyone under the then prevailing circumstances, interest rates, individual economic statuses of the students and the like. So basically you're going to make, really impose a very big mess on us. But the Supreme Court, and this is a so-called, you guys I think know this by now, their emergency docket, where we don't get a reason, but it just says we decline to change the Eighth Circuit ruling, although we expect the Eighth Circuit to act with dispatch. So the headline here is nobody's getting any more money who hasn't gotten it. That's the headline. And that's while, and you could have permitted it to go forward while you litigated whether it was legit. Instead, nobody gets any more money other than the people who have received it. And now it's in the Eighth Circuit on appeal from the district court. They will decide whether, as the 8 Republican attorneys general argue, the administration exceeded its authority under the Higher Education Act. And that case, if they rule, probably now would go back to the Supreme Court in a new administration, the Trump administration or the Harris administration. Well, actually, I shouldn't speak so fast, because in the Harris administration, if the Eighth Circuit has telegraphed it's going to strike this down. It's not certain, but that's what they're suggesting in entering the injunction. And if that is what they do, you would expect a Harris administration to petition the Supreme Court for review. If, however, there's a Trump administration, they might say that's fine. We're not going to do this anyway. He could cancel the program, might well cancel the program, might well abolish the Department of Education more than the program, if you look at Project 2025. So this is, the bottom line here is no more forgiveness for now, and what happens to this program will be first determined by the Eighth Circuit and then by the Supreme Court, but that will vary dramatically depending on who is the President of the United States. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.